The phrase minimum contacts is not well defined. We'll talk at length about what makes a sufficient contact, but what's necessary to reach minimum? There's no hard rule, actually. The courts look to the quality and nature of the contacts. This means that the better a contact is, the fewer of them, or the better the contacts are, the fewer of them one needs to satisfy the minimum contacts test. In Hansen, the Supreme Court said that contacts alone are not sufficient. The defendant must personally avail himself of the benefits and protections of the forum state. That personal availment is actually what makes personal jurisdiction. It's what makes the contact sufficient to create personal jurisdiction. In Schaefer, the Greyhound bus case, the court explained that the reason for personal availment is foreseeability. But foreseeability is a necessary condition, not sufficient. In Worldwide Volkswagen, the court held that a consumer could not sue an auto dealer out of state in a products liability suit, despite that the dealer knew that the car was mobile and might travel to the 48 contiguous states. The court said that in order for jurisdiction to exist, a defendant must pursue some sort of an active relationship with the forum state. Thus, personal availment means that the contacts must not be random. They must be intentional and calculated. Intentional and calculated should be taken very seriously. In Asahi, the tire valve case, and J. McIntyre Machinery, both involve foreign manufacturers that were hauled into court in the United States and wanted out on personal jurisdiction grounds. The court said that in both cases, merely placing a product in the stream of commerce that predictably winds up in the forum state is not sufficient to create jurisdiction in that state. Rather, the defendant must purposefully direct his conduct, or its conduct, at that forum state. J. McIntyre makes particularly clear that it is not sufficient that a manufacturer puts something in the stream of commerce and then ends up in the forum state. The manufacturer has to do more. The manufacturer must advertise and particularly target sales in the forum state in order to be subject to jurisdiction. Some particular things to look for. 1, the defendant does regular business in the forum state. 2, the defendant advertises in some significant fashion in the forum state. 3, the defendant designs a product or service for use in that state. 4, the agents of the defendant are stationed permanently or for a long period of time in order to, in a particular state to facilitate sales or other business in that state. 5, the defendant created or demonstrated some other clear intent to do business in that state. And number 6, the defendant sells a large volume of products or services in that state. And we mean a significant percentage of its total business. When assessing contacts, you want to look at the particular contacts as they relate to the particular claim in the litigation. The court might be willing to find jurisdiction even when the contacts are few, if those contacts clearly relate to the underlying claim. For example, if John punches Joe in the face while they're both in Milwaukee on vacation, Joe can likely sue John in Wisconsin for assault and battery. But he probably cannot sue John in Wisconsin for their ongoing contract dispute, which led John to punch Joe in the face while they were on vacation. A note about the internet. The status of internet business is greatly unsettled in the personal jurisdiction world. Generally, you should assume that large websites that invite sales from anywhere in the world do amount to personal availment, and thus personal jurisdiction. If the website doesn't allow customers to purchase anything, or interact with the staff in any significant way, there probably is not personal availment. However, small websites, that is, websites with very low traffic or websites for very small businesses that do most of their sales regionally, is a much closer question. If you get a question like that on your exam, the best approach is to argue both sides and just pick one. The law here is extremely unsettled.